we're asking for an adjournment. Miss Dunn has a assessment at the Sacred Heart treatment facility tomorrow. I do have verification here. It's the
defense opens with a classic delay tactic, requesting an adjournment for a treatment assessment. But here's the problem. The judge isn't just weighing the request, they're weighing the defendant's credibility. Kenzie Dunn's positive drug test and vague answers about her usage raise red flags. This isn't just about rescheduling, it's about trust.
Sacred Heart program that's up in Richmond, which I think is up in northern Macomb County. It looks like it's their model is a 12-step type approach. It is inpatient.
On an amphetamine of some type?
Excuse me, Judge?
On an amphetamine of some type?
You mean prescribed? Yeah, I don't believe so, Judge.
That should be clarified. So why is she testing positive for amphetamines?
Your Honor, I believe this was the initial test after arraignment. We are asking for an adjournment.
Will she test clean today?
I'm sorry?
Will she test clean today?
I'm not sure, to be honest.
You're not sure?
I haven't used, I know that, but I don't know.
I think she's.
Judge presses hard. Will she test clean today? The defense stumbles. This is a critical moment if Dunn can't guarantee a clean test. The court's patience wears thin. Adjournments are a privilege, not a right, and the judge is signaling that half measures won't cut it.
It's my understanding she doesn't know the half-life of it, Your Honor. I believe her initial test was.
That was she saying?
Or the 5th. Well,
When's the last time did you use?
It was a couple days ago. That's why I'm seeking in-house treatment. Your Honor.
Your Honor, I do have documentation here that she is seeking to address the root cause of any of this behavior. Like I said, she has an intake tomorrow. I can. It's at 1 p.m. That's in Richmond. She is here. This issue today. I can offer to the.
If she tests on the 6th, she's positive on the 6th. I'm now here on the 12th, and she's using by the 10th. I have no guarantee that she's going to make it even to treatment.
Yeah, I promise you, I will have my 4 kids with me, sir. Your Honor.
Your Honor, she has a lot at stake.
I understand that, including her life.
Yeah, sure.
I'll adjourn the probable cause conference March 19, 2026, 9 a.m. This time the defendant's bond is revoked. Defendant's remanded.
Thank you, Your Honor.
Laquita Thompson.
And Assistant Public Defender Nick Vukovich on behalf of Ms. Thompson, who's now approaching. Can you please state your name for the record?
Laquita Thompson.
What do we do? You're seeking an adjournment?
Yes, I am seeking an adjournment, Your Honor. And I'm prepared to address the corrections report.
Pardon?
I said there was a note for community corrections reports. I'm prepared to address that.
And
Dunn's promise to bring her 4 kids to treatment is emotionally charged, but legally, it's a gamble. The judge isn't swayed by sentiment. Actions speak louder. Revoking bond and remanding her sends a clear message. The court's priority is compliance, not excuses.
February 22nd, she blew numbers. We're at her 3 blows, then She took an EEG the next day. Came back.
Yes, Your Honor. In addressing the alleged violation, my client does indicate he does admit to drinking on that 22nd date. It was unfortunately, she did lose a friend of 24 years, someone she worked for and has known for a very long time. And unfortunately, as part of the grieving process, she does admit she did have a moment of weakness and there was a mistake and she did drink. She is working very hard on maintaining the good strides she has made in her life. She currently works 2 jobs. One where she works approximately 12-hour shifts on her feet at a manufacturing factory. She has done community service. She attends AA meetings. I actually do have AA sign-in sheets I can provide to the court and the prosecution. She attends them both in person when she's able to and on Zoom when her work schedule does not allow her to make in-person dates. I do want to note, prior to being placed on the prior to being placed on the sober link, she did have no violations on the scram tether. She had to be placed on the sober link due to issues with her ankle, and that was why at the previous PCC date you allowed her to switch over to the sober link. I do note I do understand there are several late tests. However, I do want to note several of those tests she did test within 10 minutes after the time frame occurred. I think 7 of those total. And for all of those late tests, she was negative. She does, as I indicated, work on a manufacturing line. So often, sometimes there are moments where she cannot physically step away from that line due to.
Lita Thompson's case takes a different turn. Her attorney leans into mitigation, grief, hard work, and proactive steps like AA meetings. This is textbook damage control, humanizing the defendant to